Okay, welcome back. Now we address the response. There are 4 options for response, and you have to know that response does not mean disclose documents. It means respond, and there are 4 different options, like I said: disclose the documents, deny disclosure, take an extension of time, or seek clarification, or any combination of the 4. And note that the GRC looks favorably on rolling discovery or disclosure. So if you don't have everything, you take an extension of time, but you keep disclosing documents. The valid response. Similar to a request, there's a definition for whether or not a response is valid. For starters, it must be in writing. The second thing is that the documents must be provided in the form that the requester requested them in. So if the requester asks for hard copies, they get hard copies. If they ask for electronic copies, they get electronic copies. The exception to that is if the requester does not make a specific designation, then you just assume that they want the copies in the manner in which they requested. So if they wrote in a request and they don't say, I want hard copies, you send them hard copies. If they send in an email request and they don't specify it, then you send in the request by email. Oh, this is Simone. Simone is my kitten, and one would think that I would be smart enough not to have a kitten around while I was videotaping, but it's easier to talk with somebody live in the room, so she may be making another appearance. Okay, getting back to the matters at hand. If the requester asks for something in hard copy and it's on your website, you can direct them to the website under the Rodriguez versus Keene University case. It's a GRC case, and the citation is on the slide. You say to the requester, look, this is up on my website, is that okay? The requester does not respond to you within 5 days, you're good to go. If not, that puts the ball in their court. If they say, no, I won't go on the website, then you have to send them the hard copies or whatever they asked for. The request must be timely. It must be in 7 days, unless the requester asks for what's called immediate access documents. And those include budgets, bills, contracts, and vouchers. And the way to remember immediate access documents is that they generally involve finances, such as invoices, vouchers, bills, and things of that nature. Okay, taking an extension of time. This is one of my favorite OPRA topics because it relieves a lot of angst about the OPRA responding to OPRA requests. First of all, the statute understands that 7 days is not a lot of time, or the legislature understood that. So you are allowed to take, and the operative word in that slide is take an extension of time. You advise the requester that you need additional time and you are taking it. You do it in writing, and you give them a date certain for the response. So you say, we will need additional time, we will respond by March 1st, 2020. Make sure by March 1st, 2020, you respond again. And again, respond means respond, not necessarily disclose the documents. Attorneys are notorious for saying that you need to ask the requester for an extension because we are so used to having to ask for extensions for adjournments and things. You do not have to ask. If you have an attorney that's insisting on that, then I suggest that you either direct them to this slide in this presentation or put them in contact with another attorney from another town, maybe who has more OPRA experience. So again, if you need additional time, you do it in writing, you give them a specific date, and you make sure you do not blow your own date. Okay, welcome back. These are your options for responses to unclear requests, requests that are overbroad, or requests for documents that do not exist. First, unclear requests. Please, before you answer a request, make sure that you know what the requester is asking for. You should not try and respond to something if you do not know what they're asking for. Because if you get it wrong, the requester can file a complaint with the GRC, and then the GRC is going to say that you were unresponsive. Now again, this is not the end of the world. The GRC is just a process. They don't bite. But it's unpleasant nonetheless. We'll talk more about the GRC later, but again, do not worry about it. What you should do is you should seek clarification. Now, if this requester is a gadfly and they're always asking for things, and you don't really think you can get anywhere with them, just go ahead and deny the documents. But if it's a somewhat reasonable person, just pick up the phone and say, look, I don't understand what you're asking for. They'll clarify it, and then absolutely send a responding email. Pursuant to our phone conversation, we've narrowed your request to whatever, from whatever. All of you have written confirming emails. There's no magic formula to this. Just make sure you put it in writing and then continue on with the process. One of the funny things about this particular unclear request is every once in a while when I was at the GRC, we would get a call from a custodian with a request, and they'd say, well, what does this mean? And I would always tell them, look, it's your requester, your documents. If you don't understand what it is, we're not going to understand. So if you pick up the phone and you're about to make that call, it's a clear sign that you need to ask for clarification or deny the request. Okay, the next topic are overbroad requests. Overbroad requests sound just like they are, but what the definition of them pursuant to OPRA is that it would inhibit the ability of the agency to conduct its normal operations. But basically, overbroad means just large or unduly burdensome. Say follow the same procedures as you do for an unclear request. Call the requester, see if they'll narrow it down, respond to them in writing, either confirming the narrowing down or just confirming the conversation. The next topic are documents that do not exist. Those you want to deny. There are a number of reasons why a document would not exist. One, as we've discussed before, it hasn't been created yet. They're asking for documents in the future. It did exist, but it was destroyed pursuant to the schedule for destruction, or it was destroyed for some other reason, such as a flood or a fire. Either way, document does not exist, just deny it as such. And the last caveat on the documents that do not exist category. That doesn't mean that they exist, but you just don't have them in your possession. So for example, if the documents are with your attorney, your accountant, the engineer, you have constructive possession over them, and you need to get them back from that source in order to disclose them. You can't just say that they don't exist.